Hi there, welcome Prowings CS, and today we are learning multidisciplinary case studies. Now, these case studies teach us each time something new. Let's have analysis of some of the important cases that has come up in picture lately. And Company Law Part 1, that's the cases. Each case speaks of something about it. So let's understand each one of them. Okay, first case we are taking is Pankaj Kumar Mishra, the appellant versus Registrar of Companies. Mumbai case was there, and 30th September 2020, NCLT decided this case. Now, whether the order, the question that came before NCLT was whether the order which was given by the tribunal for restoring the name of the company in the registrar of company is sustainable in law, as it has been passed without giving any reasonable opportunity of making representation or of being heard. Now look at that case, look at the question of law that was posed before NCLT. And the answer given by NCLT was that NCLT held that without giving any opportunity of being heard, the order has been passed by NCLT. Hence, the order is not sustainable in law, and therefore it is set aside. And that matter is remitted back to NCLT. So that gives a clarity that giving an opportunity of being heard is a pretty material, important thing that one has to be taken into giving before the adjudicating forum. Okay. The next case was Alibaba Nabi Bhasha, petitioner versus Small Farmers Agriculture Business Consortiums, decided on 23rd of September 2020 by the Delhi High Court. The question that posed before was whether director of the company after resignation is still liable or responsible for the daily affairs, including the checks issued and dishonored. Interesting question came before the court, and the court gave a very good answer to this. Get it? Delhi High Court held that in case where the accused has resigned from the company and form number 32 has also been submitted with the registrar of company, then in such cases, if the checks are issued subsequently and it is dishonored, it cannot be said that such an accused is in charge of or responsible for the conduct of day-to-day affairs of the company, as contemplated in Section 141, subsection 1 of the NI Act. So this case makes it far more clear that if a person he has resigned from the company and that resignation is very well accepted, then subsequent act cannot be making a person liable. Okay, so good case and good question. The other one was Dr. Rajesh Kumar Yaduvanshi versus Serious Fraud Investigation Office, 21st of September 2020. Again, Delhi High Court. The principal question that came before the court was whether the petitioner can be prosecuted for the alleged fraud committed by BSL company and or its promoters solely for the reason that the petitioner was a nominee director of BSL, and whether there is any material on record to indicate that the petitioner was complicit, that is involved in the commission of the alleged offense. Okay, these two questions came before Delhi High Court, and a very beautiful answer came out. Delhi High Court observed that there is no allegation that the petitioner director was involved in the affairs of BSL except in his capacity as a nominee director of PNB, that is Punjab National Bank. In such a capacity, he was not assigned any executive work by BSL, but was merely required to attend and participate in the board meeting of BSL. Look at the observation which is given by the court. Because this kind of observation can make non-executive directors outside the framework of liabilities. Okay, look at further. There is a material difference between the allegation that a nominee director has been negligent or has failed to discharge his responsibility. What a beautiful line. To say that a director is negligent, okay, is a different thing, and to say that the director has failed to discharge his duty and his responsibility is a different thing. So, and the allegation that has been connived or has been complicit in approving the financial statement which he knows to be false or conceals the material information, while the latter may constitute an offense under 448, the former does not. So if a director has been just negligent, he cannot be made liable for every kind of fraud and fraudulent by the promoters and directors. But if the director fails to discharge his responsibility, then the allegation and then the 448 can be put against the director. That is the observation which is coming from Delhi High Court. You can understand what a way it has been analyzed. Okay, clear? So that's one of the landmark judgment that could be helping non-executive directors especially. Okay, another case was QVC Exports Private Limited, the appellants versus Cosmic Ferro Alloys Limited. Responded 14th September 2020, NCLT judgment. What question came before that? Whether nominee directors appointed in a quasi-partnership company or a closely held company by mutual understanding between the partners can be removed by passing majority vote in the EGM after giving a special notice. Look at the question. Look at the understanding that is coming from this case. What a good question that is coming into picture. And the answer. NCLT held where a proper notice was issued to convene EGM and the same was received by the appellants, including the nominee director, but they did not make any representation, and the EGM voted for the removal of the nominee director with majority. Thus, there is no illegality in the process and the case is dismissed. So, the removal of a nominee director is held to be valid when the proper EGM was conducted and proper notices was issued. And that's why secretarial standards become an important part in this case. Okay. Next question was Economy Hotels India Services Private Limited, the appellant, versus Registrar of Companies. Responded 24th of August 2020 by NCLT. What is the question? Whether as inadvertent typographical error in the extract of the minutes characterizing special resolution and a unanimous ordinary resolution will render a resolution passed as a special resolution invalid. What a very beautiful question. You have clearly stated in the minutes as a unanimously passed ordinary resolution, whereby the requirement of the law was special resolution, and whether the unanimous ordinary resolution can be treated as a special resolution. Look at the question that has come. Okay, the answer given by NCLT was, NCLT observed that this was a case of reduction of capital under Section 66 of the Companies Act is a domestic affair of a particular company in which ordinarily a tribunal will not interfere because of the reason that it is a majority decision that prevails. The word is majority decision. As the appellant has admitted its typographical error in the extract of the minutes of the meeting characterizing a special resolution as a unanimously ordinary resolution, and also taking into consideration the fact that the appellant has filed a special resolution with ROC, which satisfies the requirement of Section 66. So it can be, that means an ordinary resolution which has been unanimously passed in Section 66 case was treated as a special resolution passed. A typographical error was ignored. So look at the fabulous thing that has come into picture. Another case, KB Brahmaji Rao, appellant versus Union of India, respondent, 17th August 2020, NCLT. The question was whether any person who is the head of some organization can be roped in and his or her assets can be attached in exercising the powers of 337 and 339 of the Companies Act. Interesting question. NCLT dealt with this one. NCLT observed that the person who may be heard, or who may be the head of some organization, cannot be roped in and his or her assets cannot be attached in exercising the power of 337 and 339 of the Companies Act. Admittedly, the appellant was the executive director of PNB, his head office at New Delhi. He was an employee of another organization. Now, can I just rope in and make him liable for the assets of the company? Okay, something like that. Therefore, he cannot be pleaded as a respondent in this case against Nirav Modi Group. Exactly, this was the case of Nirav Modi Group and Gitanjali Group of companies. And what happened? Those persons who were the head of the organization of another, but maybe acting as a nominee director on this company, they were not even aware what was going in the company. And suddenly the promoters blasted with a kind of fraud. What to do? So can we rope in the other directors and make them liable? The NCLT was damn clear. You cannot. You cannot. You can only make the promoters or the person who has been actually officers in default liable. Okay. Another case, that was Vijay Govardhan's Kalantri and others versus Unit of India, responded on 4th August 2020, and Punjab and Haryana court gave a very good judgment where the High Court can exercise the power outside the territorial states of which it is a High Court. Very good question. Whether the High Court can exercise those powers where the things are outside the states, okay, outside the jurisdiction. So look at the answer given by the High Court. Honorable Punjab and Haryana High Court, they said, observe that there is no ground whatsoever made out for invoking a jurisdiction of this code under Article 226 or 227 of the Constitution, inasmuch as neither the petitioners are the residents of Punjab, Haryana, or the Union Territory of Chandigarh, nor is the company respondent number 4, qua the petitioners were disqualified to act as directors registered with the Register of Companies of Punjab and Chandigarh. So the question is, neither the directors nor the company is falling within the jurisdiction of the High Court. How can the High Court of Punjab and Haryana could have vested with jurisdiction? Only the answer was damn clear. It was very much clear that the court does not exercise jurisdiction under writ petition under Article 226 and 227. And that's what the court said. The jurisdiction of the High Court is limited to the territorial jurisdiction of the states, of which it is the High Court. And Article 226 of the Constitution, in its clear terms, empowers the High Court to entertain a writ petition if the course of action to file such writ petition against the respondent of the said writ petition has arisen, wholly or in part, within the territorial jurisdiction of the High Court. It was far more clear what they were intending to say. Okay. Another question in another case was Aruna Oswal, appellant versus Pankaj Oswal and others responded. The matter went up to Supreme Court on 6th of July 2020. The questions that were whether the dispute raised as to the inheritance of the estate of the deceased is a civil dispute or could be said to be an act of oppression or mismanagement in the affairs of the company. Very beautiful question, because closely held company often face this kind of questions, especially on the death of the promoters. Now, whether such a dispute could be adjudicated in a company petition filed during the civil suit's pendency. So look at the question that came up before the Supreme Court, and a beautiful answer was that the Supreme Court observed that the basis of a petition is the claim by way of inheritance of 1/4 of the shareholding so as to constitute 10% of the holding. That was a requirement of operation mismanagement. This is the right which cannot be decided in proceedings under 241 or 242, that is operational mismanagement of the Companies Act. Thus, filing a petition under section 241 or 242 seeking a waiver is a misconceived exercise, and the respondent number 1 has to firmly establish his right of inheritance in the civil court. So you first have to prove that you are a shareholder. You hold that minimum 1/4 or 10% of the shareholding which you have gotten by inheritance. Till the time you prove that, you cannot be raising a question of operation or mismanagement. That's what the Supreme Court intends to say. Okay, and to the court, and more so in the view of the nomination being made as per the provisions contained in section 71 of the Companies Act. Okay, so this was a very good decision coming from the Supreme Court, answering both the questions that was raised. These were the two questions. So they settled both the questions as to the inheritance dispute as well as the dispute of referring a petition where a civil suit could have been maintained. Okay, the Register of Companies West Bengal versus Karan Kishore Samanthi. 24th of June 2020, NCLT gave the decision. Let's see the question. The issue for consideration is whether tribunal can impose compounding fees under section 441 subsection 1 of the Companies Act less than the minimum fine which is prescribed for the offense under section 165 subsection 1 read with 165 subsection 6 of the Companies Act. A great question. Can the tribunal impose a lesser fine? That's the summation. And the NCLT was clear. NCLT said, observed that the respondent has violated the provisions of section 165 subsection 1, read with section 165 subsection 3 of the Companies Act, which is punishable under section 165 subsection 6 of the Act. NCLT Kolkata bench has imposed a compounding fee of 50,000 rupees, which is less than the minimum fees which is prescribed in 165 subsection 6 of the Companies Act. Hence, the NCLT held that NCLT Kolkata has failed to notice the minimum fees prescribed under subsection 6 of 165, which was applicable. So that means the tribunal cannot impose a fine which is lesser than the fine as given in the section or the provisions of law. So even in compounding, the fine cannot be going any amount. Okay, it has to have certain basis. Okay. Another case was SP Velumani and another versus the appellants versus the Magnum Shipping Mills India. Responded on 24th of June 2020. NCLT coming into picture. And what was the question? Whether the decision of the board of directors to write off the bad debts and operation of bank account warrants a judicial interference in respect of operation mismanagement? Quite a good question again. So what did the NCLT answer? The NCLT upheld the decision of NCLT Chennai bench and held that the decision of the board of directors to write off that bad debts and is a commercial decision, which does not warrant any kind of judicial interference. The allegations made by the appellant is absolutely based. So they clearly held that you cannot bring any kind of question under the sky before the tribunal. You should have certain kind of basis. So just because there was a bad debts which were written off and the operation of bank account coming into question, that cannot be a case of operation or mismanagement. Okay, clear? So in the same matter, NCLT Chennai bench rightly opined that to invoke the provisions of operation and mismanagement, the act of the operation must be harsh and wrongful. An isolated incident may not be enough for grant of relief and a continuous course of oppressive conduct on the part of majority of shareholders, thus necessary to be proved. So it has been a landmark decision, and these kind of decisions has been persistently repeated. You have to prove a continuous act of operation or mismanagement. One isolated act cannot be held to be an act of operation or mismanagement to bring 241 or 242 before NCLT. Okay. Now, another case, late Mona Agarwal through the legal heirs, Mr. Vijay Kumar Agarwal and versus Ghaziabad Engineering Company Limited, 18th March 2020, NCLT decision. What is the question? The question for consideration is that during the pendency of a winding up petition, in the name of the company has been struck off under 248, in such circumstances, whether NCLT can proceed a winding up. That means once the name of the company has been already struck off, can NCLT start a winding up petition, entertain a winding up petition? Okay, interesting thing. NCLT was answering. NCLT observed that from subsection 8 of section 248, it is clear that section 248 in no manner will affect the powers of the tribunal to wind up a company, the name of which has been struck off from the register of companies. Look at this statement that the Honorable NCLT has clarified. You can wind up a company even after striking off. So therefore, even after the removal of the name of the company from the register of companies, NCLT can proceed with the petition of winding up of section 241 of the Companies Act. Okay, so this judgment was far more clear, to the point. Okay, the next one was Bank of Baroda versus Aban Offshore Limited. Oh, quite a good judgment, lengthy one also. So what it came out on 29th January 2020 from NCLT. The question, important question that came over here was whether any remedy under law is available to preference shareholders for filing an application for redemption of preference shares? I mean, if I'm a preference shareholder, can I have ask for a redemption of preference shares? Is there any kind of remedy? Quite an interesting question came up before NCLT, and look at the answer. It was a detailed answer, great observations. NCLT examined the intention of the legislature for enacting that Section 55 as well as Section 245 of the Companies Act, that is, class action suits. Section 55, subsection 3 of the Companies Act clearly states that the company which is not in a position to redeem its preference shares may, with the consent of 3/4 in value of preference shares, and the approval of the tribunal on the petition which is filed in this behalf, issue further redeemable preference shares of an equal amount, including the dividend, if any, in respect of unredeemed shares. However, there is no proviso in ordering such further issue. The tribunal shall forthwith order redemption of preference shares and held by such person who do not consent for further issue. So there is no such kind of provision that you can be asking for a compulsory redemption if the maturity has reached. But see the observation. The section stipulates that the company only with the requisite consent of the preference shareholders and filing a petition in this behalf before the tribunal and its consequent approval can issue further redeemable preference shares with regard to the unredeemed preference shares. Okay, see what the company can do. The section, though requires a prior consent of the shareholders, does not provide for any action that can be taken by the concerned preference shareholders prior to filing such petition by the company. So thus, the remedies which is available to the preference shareholders are only by way of consenting or dissenting with a further issue. So when the company makes you a further issue, that okay, we are not able to redeem the preference shares, but we want to give you further redeemable preference shares, it's up to you. It's up to you whether you want to accept it, whether you want to deny it. Now, only after that thing has happened, only after the thing of dissent has happened, then you could be approaching, or the company could be approaching tribunal for something to be done about those shares which are unredeemable preference shares. So, however, the intention of the legislature while promulgating Section 55 was to compulsorily provide for redemption of preference shares by doing away with the issue of irredeemable preference shares. And therefore, even though there is no specific provisions stipulated under the Companies Act through which the relief can be sought by the preference shareholders in case of non-redemption by the company or consequent non-filing of petition under Section 55. The intention of the legislature being clear and absolute. Tribunal's inherent powers can be invoked. That's a very beautiful statement. Tribunal's inherent power can be invoked to get the appropriate relief by the aggrieved shareholder. And that's what the preference shareholders are asking. That if the company is not filing petition, they're not doing anything about the redemption or even about unredeemable preference shares. So what should we do? Tribunal says, yes, you can approach NCLT by invoking appropriate relief within the inherent powers of the tribunal. See, it's coming at one of the very good judgment for preference shareholders. Okay, so alternatively, preference shareholders coming within the definition of members under Section 2, subsection 55, read with Section 88 of the Companies Act, may file a petition under Section 245, something like a class action suit, being aggrieved by the conduct of the affairs of the company. Thereby, it was held that the preference shareholders are not remediless for the redemption of preference shares. They can file an application under Section 55, subsection 3, or alternatively, they may file an application under 245 of the Companies Act as a class action suit, an NCLT, while exercising the inherent powers under Rule 11 of the NCLT rules, can pass appropriate orders. So, as I told you, it was a lengthy judgment, but it brought out one of the beautiful understanding of how preference shareholders can invoke both Section 55 or 245 in class action suits with respect to redemption of preference shares. Okay. Hence, the findings of the NCLT that the appellant, being the preference shareholders, has no locus standi to file an application for redemption of preference shares does not hold good. Okay. Another case was Joint Commissioner of Income Tax versus Reliance Jio Infocom, decided way back on 20 December 2019 by NCLT. Okay. What question came up? Whether an assumption that the scheme of compromise or arrangement may result in reduction of tax liability will furnish a basis for challenging the validity of the scheme. And that's a great question. See, majority companies do that compromise or arrangement for kind of certain kind of tax structuring. So when there is an assumption that is arising that there could be reduction of tax liability, can you be challenging a scheme of compromise and arrangement for them? Well, the NCLT gave a good clarity on that. NCLT held that without going to the record and without placing any evidence or substantiating the allegations of avoidance of tax by appearing before tribunal, it was not open to the income tax department to hold that the composite scheme of arrangement amongst the petitioner companies and their respective shareholders and the creditors is giving undue favor to the shareholders of the company. And also, overall scheme of arrangement is a tax avoidance. So NCLT was damn clear. It said income tax department cannot be approaching NCLT to challenge a scheme of compromise and arrangement on the ground that this is a tax avoidance scheme, which has been duly approved by the creditors and the shareholders of the company. NCLT observed that the mere fact that a scheme may result in reduction of tax liability does not furnish a basis of challenging the validity of a scheme. Very good decision. Another one. Register of Companies Kerala Appellant versus Ali Abdullah, 4th December 2019, NCLT, and the question was whether NCLT has power to waive off additional fees levied on the defaulted statutory documents. Oh, good one. Whether NCLT has a power to waive off that additional fees which was levied on the defaulted statutory documents. Okay. Well, 2020 amendments have come into picture, but this question came up and NCLT answer, you must see this. NCLT set aside the order of NCLT Chennai bench to the extent of the waiver of additional fees for filing a balance sheet and annual return and held. NCLT per se has no power to waive the filing fees and additional fees. So if there is additional fees which has been imposed, you cannot go to NCLT and ask that please waive it off. Okay, clear? But now 2020 amendments have come into picture in Companies Act. You must have seen that. So quite new things have come up, and the adjudicating authority or rather in-house adjudication mechanism has been given wide powers. Okay, another good one. And regional director Southern Region versus Real Image LLP, and the question was issue that came before the NCLT was the issue for the consideration for NCLT is that by applying the principle of causes omnissus, an Indian LLP, which is incorporated under the LLP Act 2008, can that be allowed to be merged into an Indian company incorporated in the Companies Act? You can understand an LLP has to be merged into a company. Both are Indian LLP, Indian company merger. It's quite a different form of organizations coming together. So can I apply a principle of causes omnissus? And what is that principle? The principle says a situation which is omitted from or not provided by the statute or regulation and therefore governed by common law. So whether we can interpret the provisions of both the law in such a way that it is helpful for the organization, where the situation is not properly dealt by the legislature in that respect. Okay, the answer given was, as per section 232 of the Companies Act, a company or companies can be merged and amalgamated into another company or companies. That is far more clear. But Companies Act has taken care of merger of LLP into a company also. In this regard, the section 366 of the Companies Act provide that for the purpose of part 1 of chapter 21, the word company includes any kind of partnership firm, limited liability partnership, cooperative society, or any other business entity which can apply for registration under this part. So that was a beautiful observation given by NCLT. Okay, clear? So it means that under this part, LLP will be treated as a company and it can apply for the registration. And once the LLP is registered as a company, then the company can merge into another company under section 232. Wow, wonderful. The NCLT further observed that the provisions of the Companies Act as a whole, in reference to the conversions of Indian LLP into Indian company, and there is no ambiguity or absurdity or anomalous results which could have been intended by the legislature. So the principle of causa omissus cannot be applied by the court except in those cases where the clear necessity is required and when the reason for it is found in the four corners of the statute. So they clarified both the things, that the provisions of that the provisions of Companies Act allow an LLP to merge. See, previously what used to happen, the LLP were converted into a company and then a company used to be merged with company. The question that directly came before that, can a LLP directly get merged? And yes, Chapter 21 was duly introduced and they allowed any kind of partnership firm, limited liability partnership, society, merger with a company as if they are a company. So that was a beautiful provision. And then NCLT clarified that on each occasion you cannot be using any kind of law, and especially the principle of causes amicus. It cannot be applied except where there is a necessity which is coming into picture. So there is no such occasion to apply in this case when the provisions of law were far more clear. Okay, clear. Another one was G. Vasudevan Petitioner versus Union of India on 2nd December 2019. Madras High Court decided that the primary issue in this case relates to whether or not the proviso of Section 167, subsection 1A, vacation of office by the director due to disqualification, was without justification, irrationally mandating the vacating of the director in the other companies while not providing the same in the defaulting companies. Look at the beautiful question that came before Madras High Court. The question was that if a director, because this question has become a, you can say, a ridiculous question before many of the companies because of the government orders of vacation of office of the directors. And the provision which was provided in Section 167, subsection 1, that the directors who is in default of the company, if that defaulting company is not rectifying, the director will not vacate the office here, but will be liable to vacate the office at all of the places. So they challenge this provision. It's an absolute irrationality. But what was the answer given by Madras High Court? Madras High Court held that the provisions of Section 167, subsection 1, clause A must be interpreted in the ordinary terms and would apply to the entirety of Section 164, including subsection 2. The court further held that the proviso can be justified on two grounds. Firstly, it has been reiterated that the exclusion of the directors from vacating their post in defaulting company while doing so in all other companies where they hold directorship has been done in order to prevent the anomalous situation, whether in the post of director in the company remains vacant in perpetuity owing to the automatic application of 167(1)(a) to newly appointed directors. So what the court was trying to say, the court said the provision was very well valid. If a person is a director of a company who is disqualified in law, it's very relevant to us to make a framework whereby he can be vacating the office in all other companies. Otherwise, all other companies will be suffering because of this kind of automatic application. And that's why he has to be removed from the other companies. Okay. Secondly, the underlying object behind the proviso to Section 167, subsection 1, clause A is seen to be same as that of 164, subsection 2, both which exist in the interest of transparency, probity, and governance. So exactly, both these sections goes hand in hand. The provisions have been weighed in a proper manner. Owing to these justifications, the court thus holds that the proviso to Section 167, subsection 1, clause A is neither manifestly arbitrary nor it does not offend any kind of fundamental rights guaranteed in Part 3 of the Constitution. So this thing was challenged under the Madras High Court under the constitutional powers, and the court was pretty much clear that the provisions are constitutionally valid. Okay. Another case, that was Mukit Patak and others versus Union of India, 4th of November 2019. The question before Delhi High Court was again in disqualification of directors in multi-phase. Let's see the first one. whether the provisions of 164 subsection 2 clause A are retrospective. Okay, Delhi High Court clarified that it was held that the provisions of section 164 subsection 2 would apply prospectively, and it is a well settled law that no statute should be construed to apply retrospectively unless such construction appears clear from the language of the enactment or otherwise necessary by the implication. It was also equally trite that the statute is not retrospective merely because it affects the existing rights or because a part of the requisite for the action is drawn from the time antecedent to its passing. So this part is far more clear that you cannot make an application of a statute from a retrospective effect unless there was a clear intention expressed in law for that thing. Okay. Second question that came was whether a prior notice and an opportunity of being heard was provided to be given before the publishing of the list of disqualified directors. Do we need to give a notice and opportunity of being heard before disqualifying a director? The answer was, with respect to second issue, it was noted that the principles of natural justice are only meant to supplement the law and are a kind of code of fair and administrative procedures in decision making. However, in the present case, the administrative authorities are not required to take qualitative decisions in as to when the director would be disqualified. Section 164 subsection 2 merely sets out the condition which, if not complied with, would disqualify a person from being reappointed or appointed as a director. Thus, it was unable to accept that thing that the exclusion of audi alterum partem, that is ruled, resulted in the procedural unfairness. So the argument which was lended that the director was not given a natural justice, an opportunity of being heard, but it was rather a technical thing. It was not something which was done with the intention, and therefore the removal of a director was held to be valid. Third question that came, whether directors of the company are disqualified from being reappointed as a director in any of the non-defaulting companies in which they were directors at the time of incurring disqualification. Again, that similar kind of question coming in a picture, and Delhi High Court answering lastly, section 164(2) provides that no person who is or has been a director of the company that has defaulted in section 164(2) shall be eligible to be reappointed as a director of that company or appointed in any other company. The expression other company is used to refer all other companies other than the companies to which it has committed the default. And therefore, this part was also clarified that incurring a disqualification makes you disqualified for all other companies. Okay, so it was also noted that the term appointment would include reappointment. Thus, it was held that the directors of the company defaulting are not eligible to be appointed or reappointed as directors in any company for a period of 5 years. It is clarified that the petitioners would continue to be liable to pay penalty as prescribed in the Act. So look at the way the interpretation was given, the understanding that has come out. It was a very beautiful case, very beautiful understanding that came out. Okay. Another good one was Jindal Steel and Power Limited, the appellant versus Arun Kumar Jagatma and others responded on 24th of October 2019. Questions before NCLT. The first one was whether in a liquidation proceedings under the Insolvency and Bankruptcy Code, the scheme of compromise and arrangement can be made in terms of 230 and 232. Interesting. I'm asking for a liquidation and can I ask for a merger, amalgamation, or a compromise arrangement? The answer given by NCLT was another landmark. NCLT observed that during the liquidation process, steps required to be taken for the revival and continuance of the corporate debtor, but protecting the corporate debtor from its management and from the death of liquidation. That means the company has not yet died. They are protecting it. They are making it surviving. So during a liquidation proceeding under the Insolvency Bankruptcy Code, petition under section 230 to 232 of the Companies Act is clearly maintainable. Second question, if so permissible, whether the promoter is eligible to file an application for compromise arrangement. while he is ineligible under Section 29A of the Insolvency and Bankruptcy Code to submit a resolution plan. So it was another good question coming into picture, that a promoter who is a person who cannot be filing a resolution plan under Section 29A of IBC, can they be filing for a compromise arrangement? NCLT further stated that even during the period of liquidation, for the purpose of Section 230 to 232 of the Companies Act, the corporate debtor is to be saved from its own management, meaning thereby that the promoters who are ineligible under Section 29A of the Insolvency and Bankruptcy Code are not entitled to file any application for compromise or arrangement in favor of Section 230 to 232 of the Companies Act. Proviso to Section 35 Clause F of the Insolvency and Bankruptcy Code, they prohibit the liquidator to sell immovable property and movable property or actionable claims of the corporate debtor in liquidation to any person who is not eligible to be a resolution applicant. So look at the way they interpreted this section and came into conclusion. The next one was S. Gopal Kumar Nair versus Ovo Betterment India, 9th of July 2019. And the question was, does the purchase of minority shares without compliance of the Companies Act amounts to operational mismanagement? Agreed. I'm purchasing a minority shares, something like 236 case. Is it operational mismanagement? In the present case, there was a gradual change in the shareholding as per the different agreements executed between OBO Germany and the appellants. However, 236 could be invoked only in case of amalgamation, share exchange, and conversion of security for any other reason. It was observed that the words "for any other reason" has to be read in agestum generis, with the preceding words, that is amalgamation, share exchange, or conversion, and must take into a same or similar color. Okay? If this was not the intention of the legislation, then it could have been generally mentioned that in the event of any person or any group of persons becoming a 90% shareholder of the equity share capital of the company, such members could express their intention to buy out the remaining stake. Okay, but this was held that the respondents could not be invoked in Section 236 to acquire the minority shares of the appellants, and the said provisions wasn't applicable to this case. Hence, the appeal was not allowed. So it was damn clear that if you are invoking a compulsory takeover, you have to have either amalgamation or share conversion or some kind of agreement to that respect. This cannot be an arbitrary act to forcefully take minority shareholders. Okay, so thank you so far and hope you're doing well. Okay, keep watching.